unmuted you, and
perfect. Yeah, thanks.
I
apologize. I apologize for being a bit late there. I had the wrong link, so thanks for your patience on that.
Hey, no problem. I'm using a new computer, and it's like driving somebody else's car. It's you think you know where the brake is, and you hope you know where the brake is, and then you find out that it's not quite in the same spot. But I'm going to begin because I know your time is precious, and I put this disclaimer up because I'm not really I'm really nobody. Not a lawyer. I'm sorry? Oh, can you hear me? Okay.
Yeah, I still got you, Tom. Thanks.
Okay. Okay. And as I said, I'm not a lawyer, but one thing I've been fortunate is to work with people and to have people around me that have taken considerable courses in real estate law. And one of the things I will tell you is that almost every attorney that I've spoken to really doesn't understand real estate law because they don't really study it. It's a discipline unto its own. And in fact, if you become a broker, a real estate broker, you're required to take 30 hours of real estate law, as to where I think most attorneys that I've talked to only spent like 6 or 8 hours. So that said, what I'm writing about here or showing you is, this is for informational purposes. I've got a lot of opinions. The fact is that this thing's going on for 22 years now, almost 22 years. And when you watch something for the last 20, as I've had, you become familiar with it, and sometimes familiarity is a issue because you tend to, gloss over things that you thought were really interesting the first time around, second, third, and fourth time, and around the 50th time, you just sort of take it for granted that people would see the same thing that you did the first time. So I'm going to begin here. This is how the mineral rights issue in Menominee County started. This is a one-page quitclaim deed, and that word quitclaim deed is important because a deed is a different it's a different vehicle, and it has different legal ramifications than what we would call a lease. A deed means that you're claiming to own it, and a lease means that we're claiming to use it based on the owner allowing us to use it. So this, again, a lot of this is probably, familiar territory for a lot of people, but this quitclaim deed doesn't have any legal descriptions. It's one page. It was filed for $9 at the Register of Deeds. And then there's this note about the line on the bottom. That'll be important to show you, later, some of the things that I think the DNR should be concerned with outside of Menominee County. So the next page here is that this is the notice of interest that was filed.
Excuse me, Tom. This is Kathleen
Yes.
Heidemann. I
Yes.
cannot see any of the pages you're talking about except in a sidebar. You're only showing the first page disclaimer right now.
Okay, hold on. Let's see. Okay, can you see it now?
Yes.
Okay, sorry. I forgot where the brake was on this car here, sort of. Okay, so this is the quitclaim deed that was filed. Notice, and again, quitclaim deeds are important. This was filed. There's no legal descriptions attached to this. It's filed for $9, and it really, the interesting thing. Again, I'm not going to get into too much in the weeds on this. Is that immediately after filling out this document, Stevenson Lumber Company, which was incorporated in 1946, dissolved itself as a corporation. So, technically they ceased to exist within a day after this. And so here's the notice of interest that was filed. notice of interest, again, is different than a deed, but this claims to own and have the right to all the ores, metals of every type, and so on. And this notice was 17 pages long. It was filed by VMS Development, which is Harry Kleiman and excuse me, Richard Lassin. They own VMS Development, and there's 900 parcels of land. And the scope of this is roughly 8% of the non-lake surface area of Menominee County was claimed. Roughly of that, 358 parcels were actually later found out to be owned by the state of Michigan. Okay, and this notice is not just claiming mineral rights, it's claiming the right to use the land, to go into the property, to explore, mine, drill, survey, access, haul, blah, 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 of every type. So they're saying that not only do we have the right to mine your property, but we have the right to explore it. And Michigan law puts mineral rights at a dominant right, and they take precedent over all other rights, including surface rights. And in this document, they also notice Public Act 42 of 1963, which is really oil and gas. And, you know, oil and gas are completely different animals than mineral rights, which are also different from lumber or trees, which are also different from sand and gravel. So when they're claiming this act, it's completely irrelevant to mineral rights. So next slide, I hope you can see this. I think it's important, you know, because part of what in fact, most of what we're talking about today is the, you know, how things got to where they're at and why we don't want people who were participating in this activity to be given leases by the state of Michigan on the land that you know, they've put up nominations for. And I think the part of that is to demonstrate the integrity or lack of persons that are, you know, that were involved in this. So this issue was written by Richard Lassin, one of the co-owners of VMS Development. If you notice the date on this, he says in June 1999, then, oops, sorry about that, hit the brake again. And then he brought in, and then they drilled a well, and the person's name was Nick Tony, and you might see MRT property listed. MRT stands for Mineral Rights Tony. So they drilled this well. They found elevated levels of zinc, 2% lead, you know, some silver, copper, and gold. So Lassin, and these are his words, he brought in Tom Quigley of Minerals Processing Corporation, and they looked at this. They tried to acquire this property. They couldn't, but in the meantime, they incorporated a number of companies that went out and claimed mineral rights, including VMS Development. And my comment on this is they didn't tell the landowner before they tried to buy this land for him, but I would assume that anybody who has 2% lead in their, you know, in the ground where their water's coming from would want to know that, particularly if you have small children and grandchildren, as Nick Tony did. Okay, again, this is really to show you how we got to where we're at. This comes from their technical report. There's numbers of these, and I've tried to be abbreviated. When I started this out about a week ago, I pulled out an old presentation. It was over 100 pages or 100 slides long. I whittled it down, and it really, this is where we start to connect the dots. You know, you can read as well as I can the highlighted yellow areas, and I will make this presentation available, so if you can't read it right now, you will at a later time. The net result is VMS Development ended up with this, you know, they formed a partnership. VMS Minerals Processing formed a partnership called Menominee River Exploration, and then, you know, Menominee River Exploration engaged American Copper and Nickel, and a bunch of monies changed hands, and American Copper and Nickel left but they retained a 7%, smelter fee on the mineral rights, which, were vast. So this also shows that, this is the number of acres that they were really concerned with. This is far beyond the number of acres they leased from the state of Michigan. And in this document, it shows that VMS Development, through a 50-year mineral lease agreement, has a 3% net smelter royalty for, this many acres, 2,670. So, they go on to another technical report, and they list that this is where they got the mineral interest, Stevenson Lumber Company, so there can be no gray areas to how they got these. And an additional, there's a person here, that they did a title search, Steve Tinte, his name will come up later. And, also it says Aquila Resources has the right to pursue its exploration plans on all of these parcels. So then we go to what happened was Aquila Resources could not sell stock. They didn't meet the qualifications. So they ended up going and finding a company in Canada called JML Resources. And JML Resources basically was almost insolvent. They had a couple claims down in, some, say, Central America. And this is really the informational background of how JML Resources merged with, Aquila Resources, really. And then at some point, it outlines the same interest or ownership. VMS Development, it goes into the background. I think things like this are important. They attempted to acquire the private property, remained unsuccessful. In later documents, you'll note that they talk about people who are they're trying to get land from as uninformed landowners. So now the number's 5,000 acres of full partial interest. Again, this is what they're offering. This is part of what they're giving. The putting on the table to become part of this, partnership with this company so they can sell stock in Canada. And this is the number of mineral rights that they know that the state has. They call this joint venture. This is now reverted back to Aquila Resources. So they're changing JML Resources, which is a backward takeover. They're now renaming it Aquila Resources. So that's how the name, stays to where it is now. And you'll see that American Copper Nickel negotiated withdrawal from the project, but retained a 7% net smelter fee. That's one of the points that we continually bring on, is that American Copper Nickel, they left this project a long time ago, but they still retain a smelter fee on lands that, that were claimed by VMS Development. Here we have the directors. Again, this is for continuity's sake. This shows you who the directors are: Richard Lassin, Harry Kleiman, VMS Development. We have Thomas Quigley, Minerals Processing Corporation. It shows the percentage. It also shows this person's title. He's director, CEO. You'll notice that, Peter Bradshaw, another person of interest, comes into this, but we also have Richard Lassin and this person named Doug Duskin, who's also a player in this, and I'll go into Mr. Duskin in a later slide. But it also says the shareholders were, these people down here below, and including, the Menominee River Exploration Corporation. So this, again, it's substance to show you that these players, which is important to remember, because at a later date when they, discuss this with the DNR, this person in particular claims not to have any, knowledge of VMS Development. So we go back, we see who ends up with what. This is the number of shares. Ultimately, you also see that Thomas Quigley is CEO and Richard Lassin is a director. You know, and again, this shows the split. And again, being somewhat redundant, showing who ends up with percentages of the company. And again, what VMS development didn't have anything. You don't ever see anybody putting any money into this. All they're doing is pledging what they claim to own, which in my opinion was VMS and their mineral rights. This came from their website. You know, again, you see director is Doug Duskin, Richard Lassin. Again, it's important to note that these two people know each other. And this issue, this brings us up, is this issue for us, meaning the community, started a long time ago. This was on their webpage. Aquila was so concerned about the community looking into the mineral rights issue that they put on their website, you know, information, you know, pertaining to it. And if you notice, this is the Aquila website, but it also is Minerals Processing Corporation, which has been and always, to my knowledge, has been Tom Quigley. So this was put on their website. Of particular interest here, you know, this is them trying to placate the community. And this, again, they put in there that no one can steal mineral rights. And that's important. That phrase is interesting because this tells you what to do, but the reality is they got involved with the DNR actually, and I'll go into that later. This slide is just again for reference. They brought in and had been involved this Steve Tinte. He's the attorney for Aquila Resources. This is a video. It's on the internet. It's on YouTube. Here's the link. I also have some audio recordings of county meetings. And this wonderful lady, Marla, asks, you know, very specific questions. This meeting was in the township, and this meeting was specific to address the mineral rights issue that the community saw. And attending this meeting were Tom Quigley, his wife, PR lady, Steve Tinte, their attorney, and then this gentleman from the DNR, Thomas Wellman. And his name shows up on many of the documents that I'm sure that are in your possession. Again, this came from their website. It really gives a background. And, you know, this is important because at a later date, much of what they're saying here really, it changes. And that to us, when there has to be continuity with companies, because again, this is about trust. You know, who should be able to lease the minerals and you know, and work with them, because if you can't believe them based on their past experience, how can you believe them going forward? This is, there was a website by a gentleman by the name of Dale Anderson, and the DNR used this website, Lynn Boyd and others, and a lot of questions were, and there was actually a mineral rights meeting in Stevenson on March 11th. And there, you know, the answer really was, the DNR's official answer was, nobody can steal your mineral rights. And if somebody claims them, they pretty much own them. You know, they also, the DNR, and I know we're dealing with different people at the DNR now, but, you know, in the past, you have to realize that the DNR, their good intentions might have been used against them, because what was happening was the DNR was basically legitimatizing the claims, saying that if somebody claims them at the courthouse, you know, they must be real. And I think this was a transition, because I interacted with not only the DNR at this time, but others in the state of Michigan, and I really don't think that people grasp, you know, what Public Act 200 of 1945 or Public Act 154 of 1997 really meant. So again, this is DNR, and there's supposed to be a committee, and the DNR kept, you know, people informed of what was going on, and that sort of petered away. This was also on that website, and this is, you know, their own open letter from, you know, that they posted to the public. Because at this time, there were also, one of the things I should have said about this meeting with Steve Tinte here is that he basically came out and said that if you go to the courthouse and you file a notice of interest on your land, we're going to protect what we own. So, okay, or we'll claim to own. And that scared a lot of people. And then later on, once the mineral rights issue became more well known, you know, Mr. Tinte changed his tune and he encouraged people to go to the courthouse and file on their own property, which, you know, really wasn't prudent, if you will. So this is their open letter. And again, it tells how they allegedly got the mineral rights from Stevenson Lumber. It goes through the background. And if you really research this, a lot of it is not really accurate because they didn't really, you know, they say they searched the title, but they didn't. So this again, this is on that website, and this is who they're talking about. At this time, Doug Duskin, the company's land agent. Okay, now again, this is important because Mr. Duskin, at a later date to the DNR, denies knowing even who, you know, who's, you know, VMS development, and he says I wasn't involved in this. Well, he apparently was. Okay, and then you know there was. You know, a lot of Tom Quigley stuff in here, lease agreements, Lynn Boyd. And Lynn Boyd basically said the company can drill on a private land without a permit, and that a mineral rights, you know, or well was a permit was not, you know, required. So again, background, this is where it came from. Then there was Tom Casperson was involved, his aide Dale McNamee, a fine gentleman, I'll add. And then Bill Haas, who is the brother of the prosecuting attorney from Menominee County, was involved. And then, you know, again, this is attempted to answer questions. So a lot of it was misleading, and it was really trying to legitimatize, you know, their claims. Now, this comes from investor presentations. I'm going to, you know, click through this really quickly. It just shows you that we have substantial information of what they said and how it changed. You know, they claimed to control the entire district, and then they were talking about how friendly legislation was in Michigan, and this is really to entice investors. Okay, they talk about you know, this many acres. They talk about how much money they're making. And this is important because later on, you know, the DNR says, hey, if anybody was hurt, it would have been the investors. And I'll draw a conclusion there. But again, this substantiates, you know, what they're saying again to investors. Again, more, this is from their presentation, you know, and, you know, this, if you notice, there's claims that they're making in Wisconsin on their presentation, because VMS Development also claimed land in Wisconsin using a quitclaim deed and using the same law in Michigan, and I'll refer to that later. But if you look at the number of land or acres in the area, you know, it's substantial. Okay, and this is a letter from you know, Tom Quigley to the township, Warshawski. And again, it goes back into some of the history, but it also, you know, gives you a flavor of the, you know, call it their approach to the township. You know, they're offering $1 million, and if you vacate a law, you know, and, you know, that to me, when somebody's saying we'll give you know, $1 million if you undo your law, which was zoning, I don't know what you call that. So jumping ahead here, this is again from JML Resources, and it, you know, it lists, you know, again, the information from, you know, again, this is certified documents that they file with the stock exchange. That, you know, it goes into the reverse takeover, and it also, you know, trying to get people even through private placements. And they, you know, the reality, the scope of this is that at this time, I think they got 25 million. Actually, they got 25 million for this. You know, this is how people invested in this company. And they, you know, they got this money by telling people this is what we have. You know, 10,000 acres, you know, we saw that number before, what they're talking about. Okay, so how do we know we're right about the mineral rights thing? And this is important again. This is that Steve Tinte, he wrote an opinion to Tom Quigley, and Tom Quigley passed this opinion on to a company or a hunt club that he had hoped to explore their property. And the hunt club basically asked him, says, well, gee, we don't know if we own our mineral rights. He said, hey, I'll check and make sure that I can drill on your land. The date's important here. This is July 2nd, 2012. Title, Mr. Quigley. Okay, this is the key point. The complications of data provided appear to indicate that the complications were current through May 1st, 2012. Now, the DNR, as far as I know, thought that this issue ended in 2011 with the release of, you know, quote, a release from the leases. Well, that's part of the problem, is that it didn't fix it. Because a deed doesn't get fixed by releasing a lease. So here's his opinion. Again, and this is abbreviated because it was a lengthy 7-page opinion that I boiled down to basically 2 pages. Okay, it tells you that the surface, and it goes into the background that the surface was always with the surface, and it says the notice of interest filed by VMS Development on this page number, filed by Richard Hennis at Lieber blah, 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 and the mineral lease from Richard Hennis to Menominee River Exploration were all void for a lack of proper mineral reservation occurred in the first place. And this, that tells you that it's void. It doesn't exist by VMS Development. Again, mineral ownership is identical with the surface. The mineral estate was never severed from the surface estate, so that was never severed. That meant that how can they come in and claim it? So the deed in which was, you know, the notice of interest refers to a deed. So it's, hey, I am making this notice based on that deed. So what they're saying is that I have a deed, a quitclaim deed on this property, and my notice of interest is telling you that I have a deed. So we've got this, again, it's recorded on this thing. It goes into, it's void. It doesn't exist. And then this is a real kicker, because apparently a guy who doesn't know VMS Development, which is Steve Tinte, is saying that it's his understanding that the VMS Development is or was and or is in the process of releasing all his mineral claims in Menominee County, Michigan. Again, this is an important date, because the DNR gave Quigley in 2010 a mandate, and it didn't happen. It says you and successor interests and so on and so forth. And remember, VMS Development was Richard Lassin and Harry Kleiman, and they are part of Aquila Resources. So this was signed to, you know, by Tinte on this such and such a date, July 2nd, 2012, and this was to Aquila Resources. So again, going back in time, there's a point where people should be, you lose the ability to defend what you did as a mistake. My opinion is at some point, if they did this thinking they were right, at some point they knew they weren't, because you know, and one of the reasons, you know, is when you get sued, which you got sued here, they got sued, Steve Tinte, you know, you have these people, this was sued by a private landowner, Thomas Quigley, American Copper Nickel, Menominee River Exploration, you know, Harry Kleiman, and Minerals Processing Corporation. Again, you can read as well as I can. Okay, they recorded notices of interest or deed, you know, notices that they had a deed on this property for minerals, and I agree with this. The kicker is this was filed by Mark Nordine. He's a landowner, but this lawsuit was handled by James Morrison, and he's an attorney, but his wife at that time was the Register of Deeds, the county clerk. So of anybody who would know about, the proper way to record, it would be the Register of Deeds, who happens to be married to the attorney who's suing, So the activities, include filing of mineral claims on vast portions of Menominee County. It would cause extreme concern on the part of all landowners, including the state of Michigan, I add. Okay, and in fact is therefore a proper subject for expropriatory damages. More of this lawsuit, talks about American Copper and Nickel filed a notice covering their and many other parcels of property and located, and it goes into this, and then it also says on this and Menominee River Exploration, a quitclaim deed purporting to convey an interest in some of the Nordine property and many other properties in Menominee County. Now, again, a deed is different than a lease. So, again, this is the background, whether you call it a lease or a sale, money changed hands. Okay, and at that time, American Copper and Nickel invested $4.9 million, with people that they thought that were managing this. So again, I don't know motivations, except that they were doing it for money. I don't know the intent, but this is their answers. And this is important because this is what we've seen on a regular basis. The last recorded claim of mineral reservation of mineral interest on any of the Nordine property is found in a quitclaim deed, and it's the 1901. And as we know, the law required people to preserve those recordings. So, they're saying that there's no consequence here because, hey, we claim 500,000 acres in the whole UP, but we don't owe anybody anything because it's, past statute of limitations. Using these claims to make millions, my opinion, what did they do, to repair this? I don't think it's repaired. And going to here, the next one, again, belaboring the point, many other properties, and these are the players that were involved in that. American Copper Nickel, Thomas Quigley. Okay, and this is the attorney for Nordine's, financial harm to the plaintiffs, and it's a permanent injunction. He's asking for that. So here we go. Again, this is Richard Lassin. And the dates change again. It's soon. I think people realize that there's liabilities when you talk about finding mineral rights and oil, lead and water, and then you do things behind the scenes. Because VMS development was incorporated after the fact, after they did that. So these claims that Lassin says, hey, I found this, or the well driller stuff, they've gone from 1999 to 2002, and they've used as late as 2003. And the reason that you have to do that is that it makes the timing, and in my opinion, the liability, it takes away people's argument that you knew ahead of time. Okay, and this is important. Aquila provided background to the DNRE, denied knowing any relationship at persons LLC VMS development, and this is a Wellman letter at DNR to Quigley, and then the Wellman second letter. The response. This is where Doug Duskin denied knowing basically who VMS development was and any involvement. Okay, this is a gift from VMS development to the state of Michigan. I raised the issue immediately after this with Lynn Boyd. I said, how can you accept what they don't own? This was for the Kearney Fen project. That name's come up. It's where, Mr. Quigley is basically now. This says VMS development gives 80 acres of mineral rights, to the state of Michigan. Wow, aren't they nice? And this is after my pursuit with Lynn Boyd, this is what she had or sent me. This is how I got it. It basically was an attorney's opinion that says that what VMS was giving, really they can't give because the state of Michigan owned them to begin with. So again, this is peripheral. This is an email from Mr. Wellman at the Michigan, and this is after the fact. And this is important. Okay, the DNR has not initiated review of possible conflicting claims and interests in other counties. Okay, he does have this copy. There are no legal descriptions attached. And it says, while the recordings of American Copper and Nickel's interest may appear to cloud the DNR's title, review of the chain of title reveals that they were built on VMS's failed claims of interest. In essence, they originally paid for, then retained an interest that they held no title to. Nonetheless, DNR is discussing with the Department of Attorney General how or if it should address these reserved interests. That's significant, in my opinion. You know, and here's, again, I said this doesn't just affect Menominee County, but that's what we're here today for. This is a peripheral letter. You know, this is a letter sent from a hunt club in Marquette County to me, or I was copied on this because Jim Keefe contacted me because people up there were concerned about mineral rights with VMS development. And they had heard I'd given some presentations to the county board. And regarding those county board, the county board did send a resolution to the prosecuting attorney asking him to send a letter to the attorney general asking for help because they were overwhelmed with the mineral rights claims. And they did. So that resolution was passed, and the letter was sent to the attorney general by the prosecuting attorney of the county of Menominee County. So here's what it broke down to: that the Kennecott people that this gentleman spoke to and this hunt club spoke to, they were basically, you know, honest. This is also had to do with meeting Tom Casperson and others. And Tom Casperson at this time was an advocate for me. And they, you know, they were going to address this issue, but also that this hunt club, Mr. Keefe said they could buy their mineral rights back for $25 an acre. Now there's 10,000 acres, that's $250,000. So, you know, again, this is another one. This was a letter sent by Mr. McNamee to Mr. Kleiman, and he said, hey, you don't own what I own, and they gave it back. Okay, then there's a lot of this stuff. There's far more than I could ever go into, but this tells you that there was meetings and that this, I had given a presentation and that this attorney then responded, Tinte, and I have a recording of that, and he basically doesn't know who, you know, VMS development is, seems to recall, and, you know, according, again, I will put this on the internet. He seems to recall that name. He seems to recall VMS was in Lansing. People said, how do we get a hold of him? He said, well, you want to go through the Department of Energy, Labor, and Economic website, do a search for their name, and it should give you their address. Okay. This is what, after that meeting, I went and I said, okay, why does Tinte not know VMS development? Why would he, you know, suggest he doesn't know them? Well, these were what he did on their behalf. On Richard Lassin, names found familiar, Tinte, another deed, Tinte, drafted by Tinte, quitclaim deed, Tinte, release of notice of interest, Tinte, you know, VMS development, Tinte. Apparently, you know, he doesn't have as good as memory as there, you know, it's selective. It's my comments. This is, he also noted at that time that VMS development put on a Facebook a offer to sell their rights back for $1. Now, this was put on June 22nd, 2010. Now, he said he had his people pop on the internet and search. This Facebook post at that time, they told you when it was posted. It was posted that same day. And if people are familiar or remember the internet, but they just recently joined the internet. If you clicked on that, it would tell you when it was that same day. And Google search did not cover or crawl, as they call it, Facebook at that time. So knowing that this existed was impossible by a Google search. Okay. Again, this is the resolution. The reason I'm pointing this out is that, there's the accountability is when people start questioning and you get sued and you start to do these investigations and supposedly you own what you own. At some point, you really, and then you keep telling people you own the mineral rights. VMS Development was also sued in Delta County by the railroad because they claim mineral rights on a railroad thing. This is from Marinette. Here's an attorney from Marinette says, in researching this act, because they used the same deed that they did, in Michigan, in Public Act 154 of 1997. He said, no application. This is a Michigan law. And again, in my opinion, recording this document, VMS Development has slandered title as real estate. I believe that VMS Development Company could be prosecuted for violation of a criminal statute and may be liable for damages in civil action. And then this is an answer, again, the same person that gave me this opinion, also told me that, hey, it's affecting other land. Here's a Inco email to, somebody who gave it to me, and also one that I wrote to Inco. And then if you notice in Wisconsin, and I'm bringing this up to show you how ridiculous some of this is. Richard Lassin was giving the mineral rights back because people there started to get mad. They sued him. They did a few other things. And what happened is Mr. Lassin, who's VMS Development, is giving the mineral rights back. He granted them back to the public. Now, you can't give something to the public unless you, through an entity. So what he did was basically did nothing, or in the worst case scenario, he's now telling the public that you have the right to the 38,000 acres of mineral rights that were claimed there. And so if you go there, you have the same right that I have. I'm just making this public. My opinion, this is an investigation that was done by the Attorney General on behalf of the DNR. I'm sure you've seen this. The conclusions, and I got 7 pages, but I believe there's more. And I'll make this, brief. It says, notice of interest, and there's, again, that notice of interest refers to a notice that we're telling you that we have a deed on this property. VMS Development Company, state comment, no idea where VMS got its interest. Okay, we talk about back 40 between these people. Okay, lease with VMS Development Company. This is American Copper Nickel, Menominee River Exploration. Again, where did they get it? That deed. And here's the a point that's still relevant, or was up till say a year ago. I don't know where it stands now. Reserves a 7% smelter fee, basically what it is, on this land acquired by Menominee River Exploration. Where did Menominee River Exploration get it? We knew that came from VMS Development. Okay, American Copper and Nickel, state of Michigan, no idea where grantor acquired the interest to give, and on and on and on. Okay, state of Michigan, VMS Development, no idea. Who's the grantor? Okay, and I got this letter, and I thought this is where we're gonna, finally get some traction here. It says, "Hey, we apologize. It's being reviewed by but our criminal division. I've asked our criminal division to respond concerning VMS Development. It's now in our opinions division, and from this point on, it went nowhere. Other counties. This was the Register of Deeds in Marquette. the quitclaim deed that I received from Stevenson Lumber to VMS was returned to the fact that it did not provide a legal description. And then, you know, it came back. And she said, when the preparer returned the document, the recording, they had added legal description attached. And then they paperclipped 17 or 20 pages of legal descriptions. So they took a document that they couldn't get registered, and then they typed it, and I'll show you that in a second. The prosecuting office has has contacted me regarding this issue. It's not being ignored. So other counties are being impacted: Marquette, Delta, Dickinson, Houghton, Marinette. Here's what they did. This is the same deed that they did in Menominee, except that they put in, Marquette, and neither the legal description or title of the subject premises, no legals. Okay, and then they put this. Then they typed this in there. It's not even the same typeface, and they typed that in there, and then they attached all the legal descriptions that they say this quitclaim deed gave them. You know, this is a certified, notarized document. If you add something to it after the fact, you know, what are you doing to that document? Again, this is people who are not just at VMS development, they are people who became Menominee River Exploration. They're people who became, major shareholders and pertinent people within Aquila Resources. So, we again here, they refer to these laws again, this public act, it's oil and gas. They claim to own all this other stuff. This is Marquette County. And this is simply just to say that, hey, a deed, and this is again, I give this person, describe the premises. Hey, you really can't if you don't put a legal description. And then it's, there's some fraudulent conveyances. Again, I'm not a lawyer. I'm just Google that. The Nordine lawsuit, again, shows you that they became aware. This is part of the was recorded. It was notice of agreement between American Copper and Nickel and Menominee River Exploration. They talk about the joint venture. They talk about the leases, and then they talk to properties granted to Menominee River Exploration by VMS Development Company. So, again, more substantiation. I think I went through that one already. This is what the DNR has on the website. They talk about, mineral rights. I appreciate that. They talk about mineral rights being the dominant estate, and the surface estate becomes a subservient state. And that means that the surface is access to anybody who claims to have the mineral rights or owns them. And, they talk about an implied easement so they can come on your property for the development of those minerals. This is the DNR's words. The mineral property is typically entitled to royalties. Well, we know that American Copper and Nickel claims 7%. We all know that VMS, based on the documents that they published, is claiming 3%. And this is the bottom line. And they put it very succinctly. Mineral ownership can have a big impact on the ability to use and enjoy the land as desired. So this is the letter that Mr. Wellman sent to Mr. Quigley at Aquila Resources. And it lists that, hey, there's a problem here because there's 358 parcels of land. And again, I'm sure you have this document that they really are owned by the state of Michigan that you claim to own. And they cite the attorney generals, they cite Aquila's recording, places a cloud of titles, and the DNR requests this party to remove those claims, but also successor, VMS Development, affiliated or successor entities, that Aquila Resources, and we know that would include American Copper and Nickel, Hudbay, Inco, and the other partners that whatever. And this, again, you guys have this, but the point of that letter, I should have pointed out, this is November 10th, 2010. this is a notice of termination. You know, it was filed on the 11th of, or excuse me, 18th of 2011, January. And this is a notice of mineral termination and release. And it basically says, hey, we're releasing these leases. Okay. And then it goes on. And, you know, the reality is that he cut Steve Tinte again, and he is noting VMS lease to Menominee River exploration. But what they're not saying is that they took the same spreadsheet that they used for some other reason, American Copper and Nickel Menominee River exploration quit claim deed. And that'll come up later. You know, this, again, going back to this date, 2010, where this letter was written, and we come to Steve Tinte's letter of July 2, 2012, and it says we still have complications. Did this do anything? It didn't remove what you were telling them to remove. They didn't comply. Then, you know, here's a kicker. This came from the DNR to me. Yeah, I did a lot of considerable, more than considerable, but the Department of Natural Resources and Environment, because remember at one time you were one organization, I think you mentioned that in your presentation, is that we're unaffected because they didn't meet the requirements. Well, she corrected me. She said they never had them because they never had them. It wasn't because they didn't do this. It was because they were never in a chain of title. And, you know, here, if VMS refuses resolutions through the courts, and she identifies this includes 28 mineral leases in Menominee County where Aquila has entered into leases on state-owned land on which VMS also claims mineral ownership. Okay, hey, that's an issue. Then the investors, okay, if DNR's title is contested mineral prevails, then the investors in Aquila that invested in minerals which Aquila did not control may suffer some loss. Okay, Aquila, their last financials showed that they raised over $105 million. They're basically bankrupt. That's why they're merging with a new company. How did that company, how did it start? We know that they gave mineral rights on the table. And American Copper and Nickel said, hey, you know, fine, here's 4.9 million, let's get together. Okay, this goes back to that deed that was for the Kearney Fen project. And and this one came from Director Humphreys at the time. So the DNR knew that mineral claims were false. The AG knew they were false. Director Humphrey notes no monetary loss for the state of Michigan on land. She did not address the fact that private landowners were impacted by these illegal claims. Properties sold for less than when somebody else owns the mineral rights or timber, sand, and gravel water rights. She did not address the fact that the state of Michigan had a moral and likely legal obligation to make other landowners aware of this issue, not just in Menominee County, but in the other counties she knew that there were illegal claims. At the point about Aquila investors, certainly the AG should have acted as selling stock and enticing partners with the illegal claims of ownerships to real property. What is that called? I can't find that. I don't know what it is. These claims, VMS development, were basis for partnerships that brought how much money to Aquila? I have no idea. But we do know that at least some came. And we also know that VMS tried to sell these mineral rights, even if it was for $1 to the public. How do you convey something that you don't own? You know, and this is the letter back to Wellman from Aquila Resources, January 21st, 2011. Okay, and I'm going to pick this apart here. It has been shown, it says, the perceived relationship between VMS Development and Aquila Resources, Inc., first paragraph of your letter, Aquila and VMS are two separate entities, standalone, and were never affiliates, parents, or subsidies of each other. I can understand the confusion. Yeah, the semantics here. One was never a subsidiary or a parent, but they were affiliated because of the Menominee River exploration and the joint venture, which became, you know, the Menominee River exploration, which then became a joint venture with First Point Minerals, which then became Aquila Resources. So, okay, next question or reply. I don't know how many other people are owners of VMS or who they may be. Aquila is not the owner of any part of VMS, or at any time VMS Development has been an owner of Aquila Resources. That's not true, because again, it goes back to how did they, the root cause is VMS and minerals processing and Menominee River exploration, and then he should know these people because he was their land agent, if you remember that slide. Again, October, the history, he talks about how it happened. Okay, it was a quitclaim deed with no legal descriptions. How did they know what they were buying? Presumably, VMS had believed it had purchased these several minerals. Presumably, after lawsuits, multiple meetings, county resolutions, private landowners demanding removal, multiple presentations, and an alleged review by an expert, Tinte, the constant lies, didn't they know they were breaking the law? Again, this is a letter to the DNR from Doug Duskin. He should know who VMS is. I don't really know how VMS came up with this list and can't speak for VMS. If you go back to that, that minerals right page, it said that the land agent spent countless hours or many hours at the courthouse reviewing title. He generated the list. Okay, two entities owned, he admits, Menominee River Exploration was formed for the purpose of this, of this project. Okay, but he doesn't jump in, and say, use the other company, that this ended up as Aquila Resources. Again, I'm losing my voice here. Okay, Menominee River Exploration leased a large acreage of VMS claimed mineral interest in Menominee County from VMS. This leasehold became subject to the American Copper and Nickel joint venture. No memorandum of this lease was recorded in Menominee Courthouse. Okay, how can you, lease and not record it? Why wouldn't you record that? Okay, and there's a pattern here. American Copper and Nickel terminated its joint venture with Menominee River Exploration. As part of its termination, American Copper and Nickel quitclaimed the joint venture. How do you do a quitclaim if you don't think you own it? The joint venture's various real estate interests in Menominee River Exploration. So they're giving something that they don't own and quitclaiming it to the Menominee River, including the VMS claim mineral leaseholds. This is a circle. VMS gives it to these people give it back. Nobody ever owned this stuff. Okay. This partial release was not recorded on this one. Not recorded, then what does that mean? It means nothing, as there's no proof it ever existed. And my comment here is, in DNR believed him? I mean, I would have certainly asked for a copy of that. And then it goes on, it says, hey, this is Menominee River Exploration was dissolved when Aquila Resources was formed. All assets of Menominee River Exploration were transferred to Aquila, including the VMS leasehold estates. Okay, if they were, if that kills this, I'll show you another slide next, is that, shows that they kept doing business. VMS was never been a shareholder of Aquila. Again, the people were, so yes, VMS may not have owned the stock outright, but the people who were on it through the joint venture did own stock. The second partial release was not recorded. Okay, they keep releasing these things and they don't record them. What good does that do anybody? Okay, by notification by VMS, this is where the state comes in. Aquila entirely and fully released all of VMS mineral lands in their lease. Well, if they did, then why did that Steve Tinte then say that it's still a problem back in 2012? Okay, and then at this point, they supposedly fully relinquished all the rights under the said lease. Okay, again, there's a difference between a lease and a quitclaim deed. And the real property covered. And it lists this, again, lease. Why didn't they provide copies of these executed agreements? If they exist and report claim interest in the state of Michigan land, they should have been part of this release as well. Okay, and remember, this is a Canadian company. If somebody wanted to go after them for, afterwards, what are we going to do? Go to Canada? So, the last part of this letter, 93 of those leases for Menominee River exploration covered, state-owned land that were part of the, the deal that they had in Menominee River exploration. Okay, and this is it. He says, I was not involved in any of the VMS to MRE leasing matters. Anyway, the bulk of those 358 parts, the bulk on your list are in other townships where Menominee River and or Aquila was never involved. So does that make any difference, where they're at? Okay, and if he's not been involved, he was the VMS's land agent. The DNR sent this letter to Quigley. Why is it Duskin saying he was not involved? Where's Quigley's reply? Was he not told to answer as, he could be prosecuted? I don't know. I'm speculating that he didn't want to do it for some reason. Again, lease, not quitclaim deeds. They talk about, you suggest, but there are still the matter of the original conflict created by the notice of interest of VMS in these lands and all the others in which Menominee River exploration or Aquila were never involved. So he's saying there still is a problem. But hey, why don't you contact Kevin Kleiman? Kevin Kleiman is Harry Kleiman's son. He was never involved in VMS development. And where's Lassin signing off on this? It's a joint venture. It's a partnership. Is Quigley also being the registered agent for American Copper, Nickel, Vale, or Hudbay? Is he signing off on it for them? Or were they even aware that this demand was made? Don't know. And the DNR assumes all this was done with the knowledge of all parties involved. Why no release that was signed by representatives at the company of these people? And again, this goes back, and this is where it says the company's land agent, and that was from that. And then and I'm not trying to be insensitive, that's not my intention. But the point being is that this Doug Duskin was involved in this. He passed away, a year later, maybe less than a year later. But the reality is it happens to us all. Okay, and that's, what we can't afford to do is have open-ended issues that the answer is, hey, you can't fix it because the guy who did it is no longer around, or woman, or whatever. And there's a history of this. You look at Minerals Processing Corporation, they've incorporated Menominee River exploration. Richard Lassin, was there. They incorporated it on this date. They dissolved it on this date, February 8th, 2006, but they tried to dissolve it by saying it was actually dissolved on the December 31st of 2004. Sorry about that. And this is important because this is in the middle of that lawsuit. They're getting sued by Mark Nordine. So they would like to have this company dissolved in the middle of a litigation. But fortunately, the state of Michigan accepts it on the date that it was filed. So Menominee River Exploration, Menominee River Exploration, I keep doing that, is only filed twice. And it was dissolved by Robin Quigley, who was a manager of here. It was incorporated, and then it was dissolved. And there is no paperwork for 2002, 23, 24, 25, and it's required, as you know, to file corporate paperwork. So there's a lax there. Okay, and again, going back to the dates of incorporation and dissolving, and this is all my opinion. Aquila, though, this part, they dissolved it, yet on on this date, they wanted to dissolve it, but it was recorded on this date. Yet there's still recordings at the courthouse for notices and deed after this date. And here they are, and so for roughly 7 more years, Menominee River Exploration kept recording, as either the principal or a party of, they were on these deeds and agreements. So the company technically ceased to exist, and yet it still participated in this. The question is how, and then ask the question of Vail, American Copper Nickel, and they're back 40. I'm sure this is, some legitimate deal. But again, people who American Copper Nickel left, what was it, 2004, 2003? So the long story is that this is the conclusion here. Excuse me. Based on the action of Tom Quigley, the DNR should not enter into any mineral leases with this individual or companies that he may or be or has been associated. Based on the actions of Tom Quigley, Aquila Resources, Menominee River Exploration, Minerals Processing Corporation, the DNR should not enter into any mineral leases with the aforementioned companies, including Aquila Resources, in their upcoming mineral lease nomination request. Furthermore, the DNR should place any leases with these persons and or entities and request the state of Michigan AG have the actions of these persons and entities investigated and provide their data to certain federal regulatory agencies that regulate stocks and the investments, as well as the FBI, is that this issue involves persons and company located in various states within the USA, but also countries outside the USA. Remember, they're a Canadian company. The integrity of certain state of Michigan agencies have been tarnished. That's a sad fact. Again, it's nothing to do with the people that the DNR that I see now. In fact, I'm encouraged by who I see. I think this is a brand new, maybe a new philosophy. But, going back to specific to the, the most recent issues, we all know the Flint water crisis, but we also know that most recently that this gentleman at Eagle, and again, Eagle used to be involved with DNRE, was caught or charged with embezzlement. I don't know if he's guilty or not, but, these are the kind of things that tarnish, the trust that the people have. So with that, I'm going to end, my part. And I don't know if you have any questions or comments. Okay, I'm trying to unmute you if you do.
Yep, I got it. Thanks. Thank you for the presentation. I appreciate the time today. I don't have any questions, so appreciate all the information and the time, like I said. But I don't have any questions at this point. Thank you.
Okay. There was a gentleman, Gary Bisa. Gary, are you on? Gary was with the Menominee Indian Tribe of Wisconsin, and Gary has been he's a very interesting man, and I think, since he's not on, I'm just going to mention something on his behalf, is that, as I said before, I tend to be somewhat confrontational, and it's not really because of the people that I'm dealing with now at the DNR. It's because of the way we were treated in the past. I hope you can appreciate that, but I also believe that we need to put, things on a level playing field, and we need to, and again, in my opinion, we need to rebuild, the community needs to rebuild the trust with the DNR. So and I know many people have said this, absolutely thank you for the opportunity to make this presentation. But also we offer at any point, because we're more familiar with the area than anybody, is that if you would like to come up to the land, that's in question, whether it's Aquila or Quigley, we'd like to show you around if you haven't already been there. But also with, specific to the Menominee Indian Tribe of Wisconsin, is, that they could show you, some things that the common or average observer would overlook because they don't know what to look for. There's a Dr. Overstreet, I believe, is on this call. He's an archaeologist, and I know that you had the state archaeologist on the last call. you know, that is new. It's respected, and we thank you for that, because, you know, in the past, it had been, it really doesn't make any difference. You know, we're going to do what we want to do. And in fact, you know, I've been through 3 contested case hearings, 50, almost 60 days in a courtroom, 10,000 plus pages of transcripts, more paperwork than you can shake a stick at. And I'm not exaggerating when I say if you would put it on end to end, it would probably be a 4-story building. You know, if you added all our exhibits and all the paperwork and all the stuff back, you know, maybe a 3-story, I did embellish, but 3-story. So that said, there are offers out there. Use, please, the resources that are at your disposal. And that's the people who walked this property. This is the people who, their, you know, ancestors were here. This is the people who, you know, that can show you things that you wouldn't see because the grass is too tall, you know. And again, I thank you, and I know I talk a great deal, and I apologize for that, but the opportunity is sincerely appreciated.
Yeah, thank you. Again, appreciate the information and the opportunity to listen. So I know we're a little bit past our time here, so I don't want to keep anybody longer than necessary. So again, thank you very much.
Okay.
And yeah.
Okay. Hey, thank you very much.
Okay. Have a great day.
Appreciate
Bye.
it. You too. Bye.
Thank you.
Thank you, Tom. Oh.
What's his name? Tom.
Congratulations, Tom. That was a fantastic presentation.
Very thorough and amazing record keeping, Tom. Thank you for being on our side.
Very good information, Tom. Where was the DEQ in 2010 doing cross verification of the mineral rights that were received and granted? Pretty fishy. Thank you.
It was very, very good. Very interesting. I learned a lot on it. It's going to help me out a lot. Thanks.
Yeah, Tom, thank you so much. I can't see how they can grant those acres now. I just can't see how they can do that.
And then turn around and resell them.
Yeah.
Huh.
No, I'm talking about the new ones.
Yeah.
They don't need to give any more acres to him.
Mm-hmm. Well, I think that you have presented institutional memory on behalf of grassroots activists. I feel like, you know, so often, like you said at the very beginning, we remember sort of only the last couple of years, and with a project that's been going on for this long, that we've been opposing for this long, it's really difficult to spin out a clear narrative of facts and supporting documents, and really the people that you're presenting to at the DNR are probably unaware of some of the deep history as well. So kudos to you for explaining it all so clearly. And I know that it's just the tip of the iceberg in terms of what you probably have for documentation of evidence, but great work.